looking at the nature of charges preferred against him, notwithstanding the fact that he is presumed innocent until proven guilty, prima facie, those charges do bring to the fore the question as to whether an accused person facing the nature of charges that he faces can be said his conduct to be that brings honor and dignity to the office. In considering this matter, Your Honor, we are alive to the fact that there is a special procedure prescribed for the removal from office of a governor, but in our humble submission, the request for the condition that we put before this court this morning does not amount to the removal of the governor from office if this court were to agree with us and deny him access to the office. You know, Article 179, sorry. Yes, Your Honor, I was at the point from office, but it is a temporary measure to secure the integrity of the trial. Articles 73 to 75. It is meant to give effect to the letter and spirit of Articles 73 to 75 of the Constitution, so that those, Your Honor, that aspire to occupy the high office of a governor must act with integrity, and once that integrity is called to question, then just like public officials, they must be prepared to stay out of office and await the hearing and determination of their cases. Your Honor, further, I wish to submit that there will be no vacuum in the governance of the county government of Garissa if the order we seek is granted. Because Article 179, Sub-Article 5, contemplates situations where a governor may be absent from office and during that absence the Constitution recognizes that the Deputy Governor shall act as the county governor. That therefore answers the question, is the term that we are seeking to buy him from office a reasonable one? And in our humble submission, we submit, yes, indeed it is. In support of our submission in this regard, I wish to rely on the case of Ferdinand Ndungu Waititu, alias Babayao, versus Republic 20. I call your attention to paragraph 48 of that decision. Yes, Your Honor. Thank you, Your Honor. Thank you, Your Honor. And the decision of Moses Kasaine Leonokulal, the governor of Samburu, from the Court of Appeal as well. Those two decisions courts below and found that barring one from access to office really does not amount to removal from office. As I conclude, allow me subsection 3A and F. And I wish to submit that under subsection 3A, the governor, that is the first accused, is under duty to provide leadership in the county governance and development responsibility. And then when you look at 3F, he is accountable for the management and use of the county. Very heavy responsibility. I point out this deliberately because of county resources and the management thereof. The investigators, having undertaken investigations, and found, of course, this will come out in evidence, mission or commission and as required by the law, reported to the DPP, who was satisfied that there is evidence to prosecute the first accused, then that calls for this court, as you consider the matter to consider. One, can we then entrust the governor to go back to his office where all these things are alleged to have happened? Can be allowed free access to documents within his office and continue managing the county affairs while he is still on trial? Possible where a governor on trial continues to run the affairs of a county, to expect that indeed witnesses from the same county would appear and testify against him freely. That's the need to secure the interests of justice. Yes, this is fine. This is fine. The appointment of county officials falls squarely on the shoulders of the governor, so that any witness listed drawn from the county is in that office courtesy of the County Public Service Board and the governor as the overall. It would be idle to imagine that indeed any possible interference with those witnesses would be remote. And naturally, his very continued occupation of that office by itself would undermine the justice of this matter. You know, we urge you then to make the order that all these officials do stay, yes, do stay away from the offices until the matter is concluded. That's all we wish to submit on this particular aspect.
Please, if you as you are addressing me on this, if you say something and it goes on record, you committed yourself not to the fact. I know why I'm saying this. And because of it, it's on issues of case management. I will guide you on this. Why is the IO stand there? Captain, I know you will not have this kind of affairs for disclosure. How ready are you for disclosure? No, let's see. The way he answers me, I'll assume you're the one talking to me because I can't put him on record. Yes. There are records that he said. Yeah, mister. Yeah? Yes, yes? One year.
the application for bail, I think I will do the way it is done and apply for the accused persons to be admitted on bail. My Lord, I take cognizance that even though Section 123 of the CPC allows the court under certain conditions to give bail, I hinge my application on a higher pedestal of Article 49(1)(h) of the Constitution. And my Lord, Article 49(1)(h) of the Constitution sets the right to bail firstly under absolute terms with no derogation or qualification in certain circumstances, but also on the other hand, it has an inbuilt constitutional clawback or derogation. And my Lord, where the court decides that the applicants have a right to bail, then there is no derogation. It is an absolute right. But my Lord, where the court denies the right due to compelling circumstances as provided for in 49(h), then there is an absolute derogation. The right has been taken away. My Lord, in light of the submissions by my learned friend, conceding that this is a case where the right to bail is available, it means they have considered that there is completely no fetter, no derogation, and no clawback in the circumstances. In other words, the court gives bail as an absolute right. And it does not lie on my learned friends to set certain conditions when they have considered to it that this is a case deserving of the right to bail. My Lord, when I come to the general principles that guide the court on the grant of the right to bail, this is an area of the law that we have rich case law, and the judiciary, my Lord, has a very comprehensive bail and policy guidelines published in 2015, 36 pages, and it's fairly comprehensive. My Lord, in that bail and bond policy guidelines, it sets two criteria to consider when the court is looking into the right to bail and bond. And the first one, my Lord, is what is called primary considerations. There are certain primary considerations you look into. And the second one, my Lord, is secondary considerations. My Lord, the primary considerations are based on constitutional rights and principles, and they take preference over the secondary considerations. And the first primary consideration the court needs to consider is the accused presumption of innocence under Article 50, subsection 2 of the Constitution. So, my Lord, when you are looking into the totality of the matter, that is the substratum of the issue you must have in mind, that the accused persons, despite the terms you said, despite the conditions you said, at the end of the day are innocent. And the terms should never, ever color that presumption of innocence. It's a primary consideration. My Lord, the second primary consideration the guidelines set for you is the accused person's liberty. Very important consideration, a Bill of Rights. And my Lord, the guidelines provide that you should not take the liberty of that person to stay with his family, to stay with his children, and to continue with his normal functions and duties. Again, my Lord, that is a primary consideration set by the Constitution. The third issue, my Lord, is the accused obligation to attend trial. It's a very important consideration, my Lord, again, for the court to ensure that the accused persons do attend trial. My Lord, the fourth primary consideration is that the court set reasonable bail and bond terms. And my Lord, that reasonable bond and bail terms, again, is premised on the importance of the right to liberty and the presumption of innocence. My Lord, if you look at the guidelines, they say that those terms should be made to ensure the accused person is present during the trial. Because, my Lord, the court must ensure that the accused does not abscond. So the terms you set should be all geared towards ensuring that the accused persons do attend trial. It should not be excessive, my Lord. It should not be sensational, my Lord. It should not be collateral, my Lord. It should not be extraneous. Those are the 4 issues the court needs to guide itself. But, my Lord, when you are setting that terms again, as I will show you later on, it all depends on the peculiar circumstance of the case. And I will show you later on, my Lord, when I address this issue, that this case has certain factual metrics that are so distinct from the cases you have previously tried or given certain conditions. My Lord, another primary consideration you should look into is the right of the accused persons and the interest of justice. But, my Lord, let me go to now the secondary considerations you should look into. My Lord, the first secondary consideration you should look into is what's called the nature of the charge or the offense and how serious it is. My Lord, when you look at the charge sheet, and my Lord, it's unfortunate that although we have many case laws that have tried to do away with the ambush by trial, I don't think it's fair for the prosecution to give us the charge sheet on the very minute when the plea is taken. If we had more time, we will have shown that actually there is no crime disclosed in this. There is no crime, absolutely no crime. And, my Lord, I'm sure at the trial we will show you that even the issues that are raised of money being transferred one account to another account does not offend even the ISPAC rules. I mean, the ISPAC rules of accounts, even that is not offended, leave alone any other statutory provisions. But, my Lord, when you look at the charge, the offenses that the 5 accused, especially, my Lord, the second to the 5th accused persons are accused of, is transferring from money from one account to another, from one bank to another. There is not a single charge, my Lord, that says that money was lost or money was misappropriated in a legal sense. My learned friends use the charge sheet in a very literal sense when they say misappropriation. My Lord, there is no charge that money was lost. There is no charge that money was stolen, my Lord. There is no charge that money was misused. What the accused persons are being accused of is mismanagement of money in a commercial sense, qualitative and quantitative analysis, that probably they built a building of this instead of this, or with these windows instead of those windows. My Lord, we will show you at the trial that that does not constitute a criminal offense in any of our statutes. My Lord, another issue, my Lord, another secondary consideration the court normally considers is what's called the strength of the prosecution case, the evidence, my Lord. And, my Lord, in the manual it says it is not how the charge sheet is framed that determines the strength of the prosecution, but rather the evidence. And, my Lord, again, it's unfortunate that we don't have the evidence. I know there have been push and pull on whether evidence should be supplied before a plea is taken. But I think, my Lord, that's one of the issues that the courts will address. Third issue, my Lord, is the character of the accused persons, the likelihood of interfering with witnesses, and other issues. My Lord, let me address you, especially the accused persons, because my learned friend has taken a lot of time on it. My Lord, the first accused person, my Lord, is the governor for county of Garissa. My Lord, county governments are one level of government, just like the national government under Article 2, subsection 2 of the Constitution. My learned friend, my Lord, has cited a number of cases that have created earthquakes and various aftershocks in the governance of county governments. But, my Lord, if you look at the case of both Francis Waititu and the case of Moses Benokulai, and then compare with this case, my Lord, these are the distinguishing facts the court should consider in addressing my learned friend's submission that the first applicant should be barred from office. My Lord, firstly, this is a case, my Lord, that where no money was lost. There's not a single penny of the county government of Garissa that has been lost, unlike the allegations made in the case of Kiambu, or even Migori, or Marlal, my Lord. So, my Lord, that's very important, where not a single penny has been lost. That is an important consideration for the court to look into. My Lord, again, the second important thing is that there is not a single allegation in the charge sheet made against the first accused persons that he participated in the pilfering or the loss of money. My Lord, if you look at the allegations in county number 2, my learned friend says that he has not provided leadership. I have never seen a criminal offense, I have never seen a criminal provision that measures the quality of leadership and says that if you don't provide a good leadership quality, you provide a criminal offense. My Lord, we will look into this another time, but the elasticity needs to be very, very concrete criminal case that does not use words like mismanagement or lack of leadership, my Lord. My Lord, the third issue is that you have not been shown government of Garissa going to his wife, going to his children, going to his relatives, going to his sidekicks. My Lord, that is a very important criteria. No evidence has been shown or no allegations has been made that the governor of Garissa and his family or his friends or his relatives have benefited from this issue. My Lord, my learned friend and the DPP, they are overreaching their constitutional mandate, and this court should take cognizance of that. If you look at the constitutional powers of the DPP, he has certain well-defined powers under Article 157 of the Constitution. And my Lord, this constitutional overreach that is becoming a norm in this country must be arrested for us to have constitutional integrity in this country. It was flabbergasting, my Lord, for my learned friend to make submission that he wants the court to enforce, and I'm using his own word, my Lord, and I quote him, he said, he wants the court to give effect to Chapter 6, my Lord. My Lord, that is not the mandate of this court. It is not the mandate of this court to give effect to Chapter 6 of the Constitution. My Lord, that is not even the mandate of the DPP to give. It is not the function of the DPP to be concerned about the integrity of public offices. There are certain constitutional structures and architecture that addresses those issues. So much makes that overreach, makes it a norm, makes it a habit, and the court addresses that. I think we are making a very, very serious mistake. The only mandate that the DPP has is to charge someone and prosecute the case in court. Get a conviction if he has evidence, or get an acquittal. So, my Lord, the issue of giving effect, and my Lord, the Constitution sets out how the leadership is enforced and which organ enforces that issue. My Lord, my learned friend took you through Article 73 of the Constitution, subsection 4 and subsection 5 of the Constitution. Again, that's not their function. My Lord, my learned friend rightly drew your attention to Section 30, subsection 3, A and F of the County Government Act, which provides the sanction of the charge sheet against the first accused persons do not establish a criminal offense. They do not establish a criminal offense. They provide certain responsibilities and functions of a governor in the county government structure. My Lord, that the found charge sheets on that section is a clear admission that the offenses the first accused persons is charged with do not have any basis in law. My Lord, my learned friend also made a very interesting statement again. His office, because it's an important office that recruits all the employees of the county government, and they fall squarely under him. My Lord, my learned friend shows lack of knowledge on how county government works. My Lord, if you will have read the County Government Act, you will have known it is the County Service Board, the equivalent of the Public Service Commission at the national level, and the county secretary, my Lord, that recruit employees, and the governor, because there is a certain level of separation of powers between the various structures of county government, does not have powers for recruitment of employees. My Lord, my learned friend also talked on witness interference, that there is a likelihood because he is a county governor, he can interfere with witnesses. My Lord, that is a grave matter. When the prosecution makes an allegation that a witness, an accused person will interfere with witnesses, that allegation, my Lord, is not a state of mind. It's not something that is in the mind of the DPP and its officers. It needs, my Lord, empirical averments on how the accused person has previously attempted or is likely to attempt to interfere with witnesses. My Lord, it's a very important allegation. It's a very serious allegation that weighs heavy in the mind of the court when you are given bail. But it is an allegation that must be grounded on empirical evidence, factual metrics, dates, instances, and evidence, my Lord. In the absence of that, my Lord, you cannot take that state of mind, my learned friend's state of mind, into consideration. One single issue. So, my Lord, in summary, we're saying that give us bail correlation, my Lord, between that office and the offense created. The transfers that are the substratum of this case from one account to the other are done by the second to fifth accused person, and the governor, my Lord, has nothing to do with this.
John, I wish to associate myself with the variable submissions of my learned senior colleague for the first accused person. My learned friend, Mr. Okello's submission. Your Honor is obliged to consider the weight of the offences. I submit, Your Honor, in considering the weight of the offences, Your Honor should consider the nature of these offences. My learned senior colleague, Your Honor, has submitted at length that in respect of these offences, they are offences really, the majority of them under the Public Finance Management Act, and there is no allegation that there is any benefit either to any of the accused person or bestowed by the act of the accused person on anyone else unlawful. And Your Honor, I submit that the contents of the document annexed to the charge sheet as Appendix 1 is of cardinal importance when Your Honor retires to consider the nature of these offences. Your Honor will note that it is at the end of the charge sheet. It is the last document in the charge sheet if we have the same document here. It is blank. At the appropriate time, I'm sure the prosecutors will apologize for that. Your Honor, may I proceed? Your Honor, in Appendix 1, it is important to note the beneficiaries of these accounts. The beneficiaries of these accounts, Your Honor, are either the county government of Garissa or the Garissa County Development Fund. You know, with tremendous respect to the prosecutors, these are perhaps clerical errors or accounts or mistakes that have been made. There is no loss given to the county government. There is no benefit. And Your Honor should consider that. And I urge, Your Honor, the nature of these charges mitigates against mitigates in favor, Your Honor, of the accused persons being admitted to bail on nominal amounts, which I submit are sufficient to secure their attendance at this trial.
That we have raised. The other matter that my lion friend raised is on the accountability of officers employed by the county government, and my lion friend did accuse us of not familiarizing ourselves with the law. But in answer, yes, only if you look at section 39 of the County Government Act, and the section makes it clear that all these officials are accountable to the county government. And finally, on the question of there not being any charge hinged on the loss of funds, in our humble submission, that is a misapprehension of the nature of economic crime, by my lion friends, because you need not lose any funds so that criminal culpability can attach. Acts and omissions of persons charged with management of public funds could attract criminal sanctions purely on procedural breaches. Therefore, the argument that there is no benefit that is quantifiable or that moves from the county government to any of these persons is neither here nor there. The nature of their offices are offices held on public trust, and the question as to the sufficiency or otherwise of the evidence, which answers the last attack on the appendix, will be a matter for the actual trial, and will be able to demonstrate, even though that the appendix shows that the beneficiary's name is the county government of Garissa, they nevertheless violated the law and must answer for such violations. And I close by making the submission that the DPP did not overreach himself by arriving at the decision to charge, and if my line of friends believe strongly that this is a case of constitutional overreach, then their own submission that this is not the proper forum for them to raise that question, because basically they are questioning the exercise of constitutional power by the DPP. We cannot have their case unheeded. It is either we are before the right forum or not. And this court should find no reason to depart from the precedent that we have placed before you and the particular provisions of the law that we have highlighted. With that, I rest our submission.
When the attempt is delivered at
10:50, much obliged.
Nada,